Welcome to the Second Reading Podcast from the University of Texas at Austin.
The Republicans were in the Democratic Party because there was only one party.
So I tell people on a regular basis, there is still a land of opportunity in America. It's called Texas.
The problem is, these departures from the Constitution, they have become the norm.
At what point must a female senator raise her hand or her voice to be recognized over the male colleagues in the room?
And hey there, Jim Henson here again. Welcome back to the Second Reading Podcast for, it's not technically the week of July 4th, but it's the week of July 4th.
It's July 4th week.
And this will be the final podcast for the first summer session, so congratulations to those of you winding down on the course, and good luck getting ready for the final. I'm happy to be joined again this week by my colleague. That actually didn't sound like I meant it, did it?
Well,
no, really. Good luck getting ready for the final.
Oh, okay. I thought you meant the part where you're saying you're happy to be joined again by me.
Well,
didn't sound true.
Maybe the insincerity is just bleeding through. I don't know. No, but really, I meant both of those things. So, Josh and I, are you still ready for the 4th of July? I didn't realize we were going to be recording again before the 4th of July. We played up the 4th of July last weekend.
Yeah, I mean, I'm probably more ready than I was last week.
And are you even more eager? Have you bought the food you're going to grill?
Yes.
Okay.
Yeah, no, beer's in the fridge. Food is ready to be grilled. I'm excited.
And we're not necessarily endorsing either alcohol or meat for that matter. Well, maybe a little.
Well, I am.
Okay. All right. We want to focus today on a decision handed down last week by the Texas Supreme Court that reversed a lower court ruling that said spouses of gay and lesbian public employees are entitled to government-subsidized same-sex marriage benefits. And the state Supreme Court on Friday unanimously ordered the case, kind of kicked out an earlier ruling that had not seen this as legit, and ordered a trial court to reconsider the case. And by not seeing it as legit, I should clarify. In other words, they said that the lower court had said, case is settled. Somebody had sued the city of Houston over them providing same-sex.
Some conservative activists.
Right, exactly.
To be fair.
Yeah, to be fair. And the case had been thrown out. They appealed it. The Supreme Court, in fact, sided with the original litigants, saying, yeah, they have to reconsider the case. So, the specific issue was the extension of benefits, insurance, et cetera, by the city of Houston to its employees. Now, this case, I think there have got to be some people out there going, wait, I thought this was settled. And this case does raise a lot of issues. So let's start with the legal status of gay marriage itself, which is the most obvious thing to respond to here, in the sense of we thought this was kind of settled already.
Right. I mean, so after the Supreme Court decision in, I guess, 2015, which basically extended marriage rights to gay and lesbian couples, basically that issue was over government benefits, and it was about whether gay and lesbian couples were eligible for the same benefits as heterosexual married couples. Was basically the main push here behind that.
And more broadly, the same legal status. But benefits were the things that were really... I mean,
that's the thing about legal status. Usually that's what you're talking about is benefits.
Yeah, health insurance.
Right, the legal status provides you with the benefits. I mean, the key here also is, you were talking about Houston and the Texas Supreme Court. I mean, this is also about the state of Texas broadly. I mean, the issue here was the Supreme Court, the U.S. Supreme Court issued the ruling, and then pretty quickly, because we're here at a university, the state university said, hey, if you've been married in another state and you're a gay couple and you want to apply for benefits, you can now. The city of Houston did the same thing. A lot of the cities moved ahead. There was a little bit of consternation right when that happened at some level around the state, but it was pretty much accepted that, this is what this meant at the time. Right?
Yeah, in fact, the state had some federal lawsuits pending that it kind of quietly dropped in the wake of this.
Right. And there were some other little outcroppings of politics that kind of spurred up around this. But for the most part, it was pretty much thought that this is what this meant. And so basically, a couple conservative activists decide, we're going to sue the city of Houston for extending benefits to gay couples. And what originally happened was they'd sort of pushed the thing along and said, basically they got thrown out, as you said. The Supreme Court says, gets petitioned to hear this, the state Supreme Court, and they said, they basically said, no, this is settled. We're not interested. And then there were letters written by the governor, the lieutenant governor, the Attorney General, all Republican statewide office holders saying, we really think you should reconsider your decision not to hear this case, including also a lot of conservative activists, pastors. Basically, the Supreme Court was lobbied.
Right. They got pressured.
And then they said, well, okay, I guess we'll hear the case. And then in the ruling they released on Friday, what they basically said was, well, the Supreme Court, and this is the quote, did not hold that states must provide the same publicly funded benefits to all married persons, which was basically how the trial court had decided to throw this out.
They had read the Supreme Court decision. Yeah.
Right, read the Supreme Court decision. And so they said, given that we don't think this is what they said, you need to reconsider how you applied the law in this case. So, look, I'm not a lawyer, as I said, I'm not a judge. You just play one. I play one on podcasts, but it does seem to me that this is the sort of way of saying, look, the Supreme Court didn't say this thing really extremely explicitly, and so therefore we don't know.
Right.
So we're going to basically kick this back to you to try again.
I mean, basically what they said was, I think the lower court had read it overly broadly, read what but the Supreme Court decision seemed to be broad in the sense of being comprehensive, as I read it.
Right.
And I think as it's been read in many other cases.
And how it was read when it was originally handed down. So, it seems like there's, I think, probably three paths this could take at this point, right? One, basically goes back down to the trial court. They look at it again and they say, yeah, no, we still think this is the same thing. Right. And then basically can get kicked back up to the Supreme Court. They could say, yeah, okay, fine, which they could totally reverse themselves.
That. Yeah, no, you followed our direction. Great.
Right. They could take it on themselves, and now we get to the branch. They could take it on themselves and say, yeah, that seems to be right, or they could take it on and say that's wrong, in which case it'll certainly be appealed to the U.S. Supreme Court, which, based on the original decision, will probably actually say, no, the trial court was probably right.
Yeah.
The trial court could take it and basically side with the conservative activists and say, I guess they don't need to extend these benefits, in which case that'll then get challenged back
and the
again.
Other side will then appeal it, and then we'll just see some variation of the same path.
Exactly.
Right.
But needless to say, this is kind of a way to just keep this in the courts for a while.
Right.
Is what this sounds like.
This leads us to another question, which is, how much is this inflected by the fact that in Texas, all of these judges that made these decisions, unlike the U.S. Supreme Court, where the judges are appointed, all these Texas judges are elected in elections just like the governor, lieutenant governor, attorney general who wrote them the letters, meaning they have to go through the primary process. They are all Republicans. They are all then subject to a very conservative electorate that we know is a much smaller subset of the state population. So, we're then stuck in this position where we are frequently in Texas, where we're trying to balance, how much can we trust the judgments of these judges to reflect both ostensibly what we want, which is that they are elected officials that are answerable to the public, but on the other hand, have a judicial temperament, which is they are reading this case on the merits, on precedent, on all of the things that we presumably expect the justice system to work on. And it's hard not to look at this and conclude that there are some politics in play. And the timetable here, I think, matters in terms of the paths that you're talking to. There isn't one of those paths that's going to happen quickly.
No.
Right? It takes a long time to get things scheduled. There's a lot of discretion at the court level. My sense is it's July of where the case gets handed down technically at the very end of June 2017. There is a primary season that is, unofficially started. Mm-hmm. We'll have a primary, as of the current scheduling in March of 2018. And we will have almost certainly no significant action or decisions on this when the primaries take place.
Which is basically what everybody wants, who's involved in this process from the judicial standpoint.
Because the way that it plays out in the primary then is that Republican candidates can say that, in fact, they've done their part to fight something that is still, not popular among a lot of conservative Republican primary voters. And, nobody can campaign against a bunch of judges saying that, as on the primary, saying that they legalize gay marriage in Texas.
Right.
Even though that makes no technical sense, just to be fair. The other statewide officials and everyone else can say that they're doing their part to fight, liberal, secular political forces emanating from elsewhere.
Going back a beat, I mean, it's interesting to me about this case is, you sort of, when you read about the judicial system in Texas politics and the elected, sort of elected judges, it's always very abstract, these arguments, these pro and con arguments about, you want judges who are, responsive to, the popular pressures and to the people, or at least you certainly don't want them totally insulated from that, right?
Right.
On the other hand, then politics can creep into decisions, and people will say, well, that never happens. And it's like, well, I think what's interesting about this, setting aside, where you come down on the issue of gay marriage, is just the fact that you can see those tensions, right? You can see the Supreme Court originally reacting to what seemed to be a pretty clear U.S. Supreme Court decision saying, this is what's going on, being pressured by sort of the most, far more well-known political figures in the state, right? Reacting to it. But then even in the way that they handled it, it kind of shows the tension, right? Because originally their judgment said, yeah, there's nothing here, so we're just going to send this back. Then they take it, and the truth is they could have ruled that, the trial court had misapplied and the Supreme Court decision did not go this far, and therefore they could have ruled that the trial court was wrong. But they didn't do that.
Right. In summary, this is unusually transparent and awkward. Mm-hmm. I mean, if you think about the interview,
but they're trying to do both here. Is the main point here, right? They're both trying to react to the partisan pressures by sort of taking the case on and sort of, as I said, keeping it alive. But also, they could have gone much further if they really believed that, sort of the arguments that were being made by conservative activists and about how to interpret the Supreme Court decision was correct. They could have just said, yeah, that's the way it is for the state.
There's a mix of politics and a nod towards procedural integrity here.
Right.
One might, put diplomatically, I guess. As you describe that, and as we think about this, as we talk about it, I mean, it is interesting how unusually public this is, and it's a combination of, there's a certain amount of, it's a little tortured.
Really? Are you sure? No, because I feel like we described this so well and so clearly.
Well, I mean, what's happened is a little tortured, and it's a little public, and it's interesting to think about it in the context of, the students in the course, and we did the interview with former Chief Justice Wallace Jefferson. And he's been a big advocate of reforming this system of elected judges and thinking it doesn't really work. He was really talking more about the campaigning and the time commitments and appearances, and this is kind of an outlier case in the extent of its publicity and the straightforwardness with which,
right?
Now that isn't neither makes nor breaks the case, but I think it's one thing to really notice about this,
right?
And another piece of this is that, public opinion is pretty complicated on this, but shows clear partisan patterns. Right.
So we've been polling on gay marriage here in Texas for quite a while. In fact, so long that we actually have, our trend kind of got ruined. So we had this question for a while that basically asked people whether they think that gays and lesbians should have the right to marry, should have the right to civil unions, which you may not even know was a thing given your age, or just basically not have a right to gay marriage or civil unions. And that was the question we had for a long time on our UT Texas Tribune polls, because there was still a discussion about whether, there'd be this sort of full marriage rights or this sort of subclass of like civil unions, or whether everything should be civil unions and that marriage was a religious institution or whatever.
Right. And what civil unions were, it would basically was a way of taking care of some of these benefits issues, basically the legal status. It gave you a legal status that somehow enabled people to separate it, that enabled people to separate it from the religious status accorded to marriage.
Right. And eventually that, sort of fell by the wayside, and it was sort of marriage equality or nothing.
Yeah. And
we shifted sort of to basically, a question more along the lines of, should gays and lesbians have the right to marry?
Or not.
Or not, basically. And so, going back to 2015, Texas was pretty split. It was about, 43% supported gay marriage, 43% opposed it. Pretty sharp partisan differences. So 59 to 60% of Republicans were opposed to gay marriage. 65% of Democrats were supportive of gay marriage. Fast forward to basically June 2017, and the state has become, majority supportive of gay marriage. 55% support it, 32% opposed. But those partisan patterns still stick. So whereas Republican support has increased from about 25% to 32%, a majority of Republicans, 52%, still oppose gay marriage in Texas.
And that's the key number.
And that, remember, that's among all Republicans. If we start to say, like, if we look at the most conservative corners of the Republican electorate, the sort of small groups of people who actually show up in Republican primaries, and the sort of people who actually are probably going to be aware of a gay marriage.
That all this is going on.
Of a decision relating to gay marriage
Yeah.
amongst the Supreme Court justices in Texas, that opposition is much higher.
And in terms of the mechanics of that, basically, those people that have the most intense opinions are going to be the people that are going to be the targets for mobilization, for mail, for all the efforts to get out the vote in the Republican primary.
Right, because basically, if you think about like who shows up in the Republican primary, what you can basically say is it's the most conservative of conservative voters and the most conservative elements of the Republican Party, and not totally distinct, but a little bit is also sort of religious fundamentalist,
Right?
Voters,
The evangelical
voters,
Christians,
right? Who are obviously very opposed to gay marriage.
right?
And so that's where you can kind of see the politics of this intersecting, and both the pressure that was being exerted on the governor and the lieutenant governor and the attorney general. Not that they disagree,
Right.
but also that's where they're feeling the pressure
Right.
points. And that's what they were channeling to the justices to remind them about, which the justices clearly reacted to and saying, well, let's, I guess we're going to do
They reacted to something.
Right. And so that's why, there's no reason, like, just because the Supreme Court decided this and everyone sort of said, oh, well, this is decided now. Not so fast, because in the end, elected officials, including judges, are responsive to the publics that elect them. And in Texas, a majority of the majority party's public is still not come along and accepting that this is kind of the law of the land now.
And so basically, we're going to talk about it a little more.
Yeah.
And we're going to talk about it at a time that happens to be in the run-up to the primary.
Yeah, and you're going to fight the good fight. That's the other part of this, right? I'm not saying it's the good fight personally.
I know, but that's the signal you're sending to this constituency.
You may lose, and you probably are going to lose, is what it looks like. But the point being, now look, maybe not. Part of it is you draw this out. Ruth Bader Ginsburg, dies or retires,
Right.
Justice Breyer retires.
Maybe there's a reversal on this.
Yeah, it's
or at least some sense of a little bit of rollback. I doubt there's whole reversal, but point well taken.
But it's not impossible. But the point is, at the same time, this is more about showing that you're still fighting.
It's signaling, basically. It enables the elected officials involved to signal to the audience they want to signal to that they agree with them.
I think the most notable thing, in some ways about this, and it's only come out as we've been talking about. It's a point I made, so let me go back to it.
An excellent point
I think
you
it was
made,
a good
I'm
point,
sure. I
so
don't know which one you're
I'm
going to
gonna
make, but it was a
reiterate
very
it.
good one.
But I think it was that, if the judges really wanted to, they could have made a much more forceful show on this. The fact that they didn't kind of shows that they know that they probably would just be precipitating, a Supreme
They know
Court.
what the most likely path this is going to take.
Right, which is it goes to the Supreme Court and the Supreme Court says, no,
Yeah,
this has already been decided.
Right. And that was a good point. That was a good point.
Thanks.
I thought that as you were saying it.
Okay, good.
And so I think, before we wind up, and we're gonna keep it short as a gift to people because you've got studying to do.
And it's July 4th.
And it's July 4th week. But one thing, again, if you kind of step back, you can kind of see this in the overall pattern of things that we've been talking about in terms of the sequence of where the state is and kind of the political cycle, right? So we're going into this special session in which much of the agenda of the special session is actually of a piece of the political thinking that seems to be informing both, the state officials' pressure on the court and the court's response to that pressure. And that is, we're in the part of the cycle where the statewide elected officials are all running. There's going to be a relatively high-profile primary election. There probably won't be a ton of contests at the top level, but there's a lot of positioning going on that is very hyper-aware of what the composition of the electorate is going to be in that election, and that's rippling through institutional and individual behavior.
Well, and just to say, that sort of positioning and the lack of competition is endogenous. You can look it up, right? Because
It's internal to the process, basically.
There we go. Well, I want to look it up. But the point, that's going to be a good test question.
Is there something orthogonal to that?
Oh, there's definitely things that are orthogonal to that. But anyway, as we riff on, but the point here is part of the reason that it's going to be a relatively, unchallenging process for the statewide officials in terms of who is going to, challenge Governor Abbott or Lieutenant Governor Patrick or Paxton is all this positioning?
Or any of those justices that are up.
Right, is all this positioning. I mean, it's pretty clear had the judges kind of continued and decided with their original decision not to hear this case, the likelihood that they would have faced a primary challenge would have increased dramatically.
Right. So, and with that, hope you've enjoyed the class. Hope you've enjoyed the podcast. Good luck wrapping up the class and enjoy the rest of the summer. The Second Reading Podcast is a production of the Texas Politics Project and the Project 2021 Development Studio at the University of Texas at Austin.